Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. Imagine you're about to buy a car, and the seller tells you it's only had one careful owner. Or perhaps you're buying a business and you're told that the profits are excellent. Or maybe you're buying a property and the seller assures you there are no problems with the building. You rely on those statements, you enter into the contract, and then you discover that they weren't true. The obvious question becomes, what can you do about it? And that's exactly what this video is all about. Now, every misrepresentation problem starts with a simple issue. Was the claimant induced into the contract by something that wasn't true? If the answer is yes, the contract itself may be defective, and that can unlock some very powerful remedies. So let's take this one step at a time. The first step, before we can even discuss misrepresentation, we need to identify what kind of statement we're dealing with, because not every false statement is a misrepresentation, and not every false statement is a contractual term. So there are three types of pre-contract statements that you need to know in terms of answering SQE questions. There are what are known as sales puff, contract terms, and representations. Now, sales puff is the easiest category out of all of them. And sales puff is simply exaggerated sales talk. Statements like the best car in Britain or the holiday of a lifetime, these are not intended to be taken literally. Reasonable people recognize them as advertising language, so they are generally not actionable. At the other end of the spectrum are contractual terms. These are promises that become part of the contract itself. If they turn out to be untrue, the remedy is breach of contract, not misrepresentation. So that leaves us with these representations, which actually sit in the middle. These are statements that persuade somebody to enter into a contract, but do not actually become contractual terms. If such statements are false, they are actionable as misrepresentations. So how do we tell the difference? Well, the courts are trying to discover one thing. What did the parties intend? So several factors help us to answer that question. For example, did one party have specialist knowledge? Was the statement especially important? Was the statement included in the final written contract? Was the other party encouraged to verify the statement? And how much time passed before the contract was formed? These factors help determine whether the statement is a term or merely a representation. So what is misrepresentation? Well, now we can define it. A misrepresentation is an untrue statement of fact made by one contracting party to another, which induces the contract to be formed. And there are four parts to that definition. Let's break them down. Firstly, an untrue statement. The statement may be spoken, written, or even communicated through conduct. Sometimes actions do speak louder than words. But what about silence? Well, students often assume silence can amount to misrepresentation, but generally it cannot. Contract law usually operates on a buyer beware basis, and there is normally no duty to volunteer information. There are some important exceptions to that though, and silence may become actionable where there is a fiduciary relationship, where the contract requires utmost good faith, where a half-truth creates a misleading impression, or where a statement becomes false because circumstances change before the contract is formed. And these situations are far more dangerous. Now, the second requirement in our definition is that the statement must concern fact, not opinion, and not merely future intention. Now, why does this matter? Well, because people are allowed to hold opinions and people are allowed to make predictions. If those opinions later turn out to be wrong, that does not automatically create liability. But once again, there is an exception. So if somebody claims to hold an opinion when they have no reasonable basis for it, or there are lies about their future intentions, the court may treat the statement as one of fact. In reality, they are misrepresenting what they already know or what their intentions are. Returning to our definition and looking at the third part, made by one contracting party to the other. So the statement must come from the other contracting party. If the statement comes from a third party, misrepresentation will usually not apply. Other legal claims may be possible, but not misrepresentation itself. And then we get to inducement, and this is the final requirement. The statement must have influenced the decision to enter the contract. In other words, the claimant must have relied upon it. Now, does it have to be the only reason? No. And this is important. The statement simply needs to be one reason for entering the contract. It does not have to be the only reason. Now, there are three types of misrepresentation. So once we've identified that a misrepresentation exists, we need to classify it. Why? Well, because each individual classification actually adjusts the remedies that would be available. So there are three categories: fraudulent, negligent, innocent. Now, fraudulent misrepresentation is the most serious. The statement is made knowing it is false, without belief in its truth, or it is made recklessly. And this is essentially dishonesty. And the person making the statement either knew it was false or didn't care whether it was true. Now, this is important because the law treats deliberate deception harshly. Damages are available and they can be expensive. The aim is to place the claimant in the position they would have occupied if the misrepresentation had never been made. Now we need to move down a level with negligent misrepresentation. The statement isn't deliberately dishonest, but it is careless. The speaker honestly believes it is true. However, they had no reasonable grounds for that belief. Now, for SQE purposes, negligent misrepresentation is extremely important because the burden of proof shifts. The defendant must prove they had reasonable grounds for their belief, and that can actually be surprisingly difficult. Finally, we reach innocent misrepresentation. Here, the statement is false, but the person making it genuinely and reasonably believed it was true. There is no dishonesty, no carelessness, just an error. Now, innocent misrepresentation generally does not give rise to damages automatically, but another remedy may still be available, which brings us to rescission. Now, rescission is probably the most distinctive remedy in this entire topic. The idea is simple: undo the contract, put the parties back where they started, hit the rewind button. Now, what happens here? Well, each party returns what they have received. Money goes back, property goes back, future obligations disappear. The aim is to restore the parties to their pre-contract positions. The important point then: misrepresentation makes a contract voidable, not void. And that means the innocent party has a choice. They can affirm the contract or rescind it. Now, rescission is an equitable remedy, so certain bars may prevent it, and these would include affirmation, so we've continued with the contract, delay unreasonably, intervention of innocent third-party rights, so somebody else might be affected, or impossibility of restoring the parties to their original positions. If any of these bars exist, rescission already may no longer be available. So damages or rescission? Students often ask which remedy applies, and the answer is often both. Rescission and damages can sometimes operate together. Rescission deals with the contract, damages deal with the loss. So what's Bowdie's bottom line? Well, every misrepresentation question can be tackled with a simple framework. First, ask, was there an untrue statement? Then, was it a statement of fact? Then, did it induce the contract? If yes, then classify it. Was it fraudulent, negligent, or innocent? Finally, ask, does the claimant want to keep the contract or escape from it? Because that determines whether you're looking at damages, rescission, or both. And remember, misrepresentation isn't about broken promises. It's about being persuaded into a contract by something that wasn't true. And that's the key idea that you've got to keep in mind when looking at this topic. Thanks for watching this Bowdie Shorts episode. Please view further episodes available now via our YouTube channel.